Good morning, everyone, and welcome. It is my pleasure to reconvene the 21st meeting of the Joint Select Committee on Human Rights, Equality and Diversity, and to welcome everyone who is here. This public hearing is being broadcast on Parliament Channel 11, Parliament Radio 105.5 FM, and the Parliament's YouTube channel, ParlView. I want to welcome the officials from the Ministry of National Security who are here with us, as well as the officials from the Living Water community. My name is Nian Gatsby-Dolly, and I am the chairman of this Joint Select Committee, and I now invite my members to introduce themselves.
Good morning. I am Dineshwar Mahabir, Independent Senator, member of the committee.
Good morning. My name is Kazim Hussein, member.
Good morning to all. My name is Dennis Moses, member.
Good morning all. Saddam Hussein, Opposition Senator, member.
Good morning to all. My name is Glenda Jennings-Smith, Vice Chairman.
May I now invite the officials from the Ministry of National Security, followed by the officials from the Living Water community, to introduce themselves.
Good morning, Chairman and members of the committee. Vel Lewis, Permanent Secretary of the Ministry of National Security.
Good morning. I am Shamin Gandhi Andrews, Acting Chief Immigration Officer.
Good morning. I am Dennison Ailey, Immigration Officer 4 at the Immigration Detention Center.
Good morning, all. I am Kent Downer, Senior EMT, Emergency Management Technician at the Immigration Detention Center.
Keith Reno, Director in the Office of Law Enforcement Policy at the Ministry of National Security.
Patrick Cunningham, I head the Program Management Unit at the Ministry of National Security.
Good morning. I am Gina Maraj from Living Water Community.
Good morning. I am Alison Weeks, Living Water Community.
Pleasant good morning. I am Ganesh Rampasad, Legal Officer 1, Living Water Community.
Thank you so much, and it's a pleasure to have you all here with us this morning. This morning, we are here to continue discussions into the treatment of detainees at the Immigration Detention Center. Just by way of background, on April 6, 2018, the JSC on Human Rights, Equality and Diversity held an inquiry into the treatment of detainees at the Immigration Detention Center in Santa Rosa and Aripo. Further to this, on June 1st, 2018, the committee visited the detention center at Aripo. Based on the substance of our first public hearing, the discussion that ensued, and the observations that were made on the site visit, in addition to further submissions from agencies such as UNHCR, the United Nations High Commissioner for Refugees and Living Water Community, and the Ministry of National Security in the Immigration Division, the committee has asked for another public hearing to clarify certain issues which we encountered, and so we are happy to have you here so that we can further this discussion to make our report more fulsome. Our objectives of this inquiry are to determine the treatment of detainees at the Immigration Detention Center and also to examine the physical conditions at the Immigration Detention Center, which would have underpinned our site visit. We received written submissions from the Ministry of National Security, the Living Water Community, United Nations High Commission for Refugees, Office of the Ombudsman of Trinidad and Tobago, and the Emancipation Support Committee. The viewers and listeners who are following today's inquiry or public hearing can send questions related to today's topic via email at parl101@ttparliament.org. That's parl, P-A-R-L 101 at ttparliament.org, on Facebook at ttparliament, and on Twitter at ttparliament. I'd now like to invite brief opening statements from Mr. Vel Lewis, the Permanent Secretary of the Ministry of National Security, and Ms. Gina Maraj, Legal Officer of the Living Water Community. Mr. Lewis, and then we'll have Ms. Maraj.
Thank you very much, Madam Chairman. The Ministry of National Security welcomes this opportunity to address the concerns of the Joint Select Committee on Human Rights, Equality and diversity in your continued inquiry into the treatment of detainees at the Immigration Detention Center. Permit me, Madam Chairman, to state that migration into Trinidad and Tobago is governed by laws that set out, among other things, who can legally reside in the country, who are prohibited immigrants or permitted entrance, the criteria for remaining in the country legally, offenses and penalties, and the process for detaining and deporting those who have breached the laws. Sorry. In effecting those laws, the Ministry of National Security remains committed to ensuring that all persons are treated fairly and with dignity. To ensure that foreign nationals who have run afoul of the immigration laws, are not kept in prison facilities and treated in the same manner as criminal offenders, the government in November 2009 established the Immigration Detention Center to house foreigners in breach of the Immigration Act. The facility has a capacity ideally of 150 inmates, which is broken up into approximately 115 males and 35 females. It is recognized that detainees come from various countries around the world, and several obstacles to their repatriation can arise, including a lack of documentation, an inability to identify the detainee, lack of cooperation by detainees, and the demands of airlines and transit countries. While the Immigration Division has improved its processing time from detention to the order of removal, these obstacles can prolong the length of stay at the Immigration Detention Center. Over the last year, the Ministry of National Security has expended considerable sums to upgrade the detention center and to improve the living conditions of the detainees while they are processed through to removal to their home country. More work is currently ongoing to ensure the security and safety of the detainees as well as the employees, and of course to improve the living and working conditions at the center. The team here today, Madam Chairman and members, are willing and happy to address any concerns that the committee may have at this time. I thank you very much.
Thank you, Ms. Maraj.
Madam Chairman, members of the Honorable Joint Select Committee, and members of the Ministry of National Security, Living Water Community would like to thank you for the opportunity to be here today on this further inquiry into the treatment of detainees at the Immigration Detention Center. The Ministry for Migrants and Refugees at Living Water Community works with vulnerable migrants and refugees who are otherwise known to us as persons of concern. Under this mandate, Living Water Community offers services such as legal, healthcare, assistance to victims of trafficking and unaccompanied minors, offering protection to these persons of concern. One of the fundamental aspects of this protection relates to detention. The detention of asylum seekers should normally be avoided and be a measure of last resort. Detention should be necessary, legitimate, reasonable, and proportionate. The right to liberty and security of the person are fundamental human rights reflected in the Constitution of the Republic of Trinidad and Tobago and the International Prohibition on Arbitrary Detention. Whilst we accept that for reasons of national security, detention may at times be necessary, same ought not to be arbitrary or unreasonable. The International Detention Coalition has been able to identify over 250 alternatives to detention in 60 countries worldwide. Alternatives are significantly more cost-effective than custodial detention. One alternative to detention that has been practiced in Trinidad and Tobago for asylum seekers and other migrants is the use of the Order of Supervision document, which provides reporting mechanisms for persons who are illegal within the country. Alternatives must also be considered, and detention ought to be avoided or considered as a last resort for the elderly, pregnant, sick, handicapped, and mentally ill where safety or security is not an issue. It is important to note that the deprivation of a person's liberty must be subject to minimal procedural safeguards, such as the option to contest the detention. Also, a periodic review of the detention to ensure that a lawful detention does not eventually become arbitrary should also be conducted. Furthermore, where detention is necessary, persons of concern or asylum seekers ought to be treated with dignity, respect, have access to proper medical care, be afforded legal representation, access to asylum procedures, and be protected from deportation, otherwise known as refoulement. We thank you.
Thank you so much. We will now begin our questioning, and we remind all members and all officials to direct your questions through the chair so that we'll have a very orderly process this morning, as usual. I'd like to begin by emphasizing, for the benefit of our listening and viewing public, that this is our second public hearing on this matter, and therefore there may be some issues that we will not rehash, having gone through those before, and that what we are really trying to do is to seek clarification on some of the issues that we believe bore further investigation. So let me begin by asking for some clarification on this order of supervision process. On our site visit, we were speaking with some of the officials and recognized from their submissions to us that there were quite a number of people who were not legally in the country but were not detained at the Immigration Detention Center. Could we get some clarification on if there are numbers to assist us with respect to how many people are illegally in the country, have been discovered, how many are detained, and what is this order of supervision process, and how that is treated within the context of illegal immigrants?
Thank you, Chair. What we have seen recently is that there has been an increase in the numbers of persons who are entering illegally. The actual number we won't be able to give because a lot of the persons who have entered we know nothing about. From what we see at the detention center, those persons, we have currently just about 110 detainees at the detention center. Actually 118, forgive me, Chair, as at this morning. And of that number, at least 75% of them would have entered the country illegally. Of the numbers, most of them are, in fact, Venezuelan nationals, and apart from entering illegally, they have no documentation. So that's just a synopsis of what I can tell you, what we have been seeing. And over the last year, most of the persons, especially of a Venezuelan nationality, have entered the country illegally, and that number has been growing. So far this year, we have just about 19,000 Venezuelans entering at a legal port of entry. And of that number, at least 17% of them have overstayed their time. Some of them we have in detention, some who would have been able to be assessed and have some form of some place to stay, somebody who is willing to support them while they are here. We would consider the risk and we would put that person on an order of supervision. An order of supervision really is akin to bail. So that depending on the person who is in front of us and the nature of their breach of the Immigration Act, the Chief Immigration Officer would be able to determine whether or not that person can be released on an order of supervision and under what terms and conditions. More often than not, we would release those persons when they post a security bond, which is to offset the repatriation of the individual should they be deported, and other reporting requirements. So a place to stay, who is supporting them, and we would take telephone contacts. We would have them report at particular periods of time. It could be every month, it could be every week. It just depends on the nature of the breach. So the order of supervision really is to facilitate those persons, not putting them in detention. We have currently just about 1,700 persons on orders of supervision as compared to 118 persons actually in detention. And the persons... 1,700, yes. And the persons who are actually in detention are those persons who the officers in the enforcement unit may have considered to be high risk, or they're waiting some form of identification for them, and somebody to come forward to say, okay, yes, we would be willing to support them, they're willing to post a security bond, etc. So it's not an automatic thing to put somebody on an order of supervision.
Could I just ask a follow-up there? That security bond, does it vary in the amount, depending on the circumstances, and what's a typical range?
It varies by nationality, and it takes into consideration the cost of repatriation of that person to their home country. So, for example, somebody from, let's say, Guyana might be paying $2,000 because of the cost of a ticket to return to their home country, as compared to somebody who might be from an African country where the cost is closer to $30,000 to purchase a one-way ticket to their home country. And that's just really the cost of the airline ticket. It does not take into consideration the actual cost of detention, or if we have to pay for escorts to take those persons back to their home country.
Senator Hussain and then Senator Mahabir.
Thank you very much, Chair. With regards to the order, through Chair, of course, with regards to the order of supervision, these persons would be either before a special inquiry of the Immigration Center. Now, can you give us an estimation of how long do these specific cases take to be completed?
It varies, and it depends on what documentation we have in front of us. So if the person does not have identification, if we cannot verify their nationality, there's a process for that going through Foreign Affairs to get to their embassy to determine if that person is in fact a national of that country, all right? So it starts with identifying them. Then, of course, it depends on the nature of the breach. Are we prosecuting them for the breach of the Immigration Act? And if, for example, they're entered illegally and they are taken before the court, they are fined, they're given time to pay the fine. And therefore, we await the time for them to pay the fine, after which, if the fine isn't paid, then a warrant is issued for them to serve their time. So they must serve their time first. And then, following that, is the whole process now of their repatriation. Depends on their cooperation as well, so that a number of them either do not want to sign documents if we have to acquire a visa for them to transit through a particular country, and we can't sign the visa form on their behalf. So we have to wait on the detainee to really cooperate with us before we can actually do a repatriation. Then it is either they provide a ticket for their repatriation, or the government has to provide a ticket for their repatriation. So then we need to seek approval from the permanent secretary to purchase a ticket for their repatriation. Some of the airlines require escorts for the detainees, and those escorts are usually police officers. So we have to get permission, and the police service will identify which officers and give approval for those persons. And, of course, acquiring the funds and whatnot. So it varies. The timeline varies. If everything is smooth and we have all of the documentation, within a month at maximum, that person can be removed from the country. In some cases, it has been as little as a week.
Okay. I saw that there's a large number of persons on the supervision, 1,700 you mentioned. How many of these special inquiry officers that you all have at the division to manage these matters? Because it's quite a lot.
We have, right now, the minister has actually deemed 19 people as special inquiry officers. The challenge with that is that you also have to have a stenographer to take the minutes. And we really don't have stenographers in the public service.
Yes.
So that poses a challenge. We have at least three dedicated persons. Yes, strangely enough, I only have one stenographer on staff right now. Two, to be exact. So that it's a challenge for us. We have 2 dedicated officers doing at least 5 special inquiries every day, Monday to Friday. Of course, if a stenographer stays home or somebody falls ill or whatnot, that presents a challenge for us, or anything else. But we have at least 2 and at least 5 special inquiries going on every single day. From time to time, we would do what I call a blitz, and perhaps one week call a lot of special inquiry officers together. And once we can identify stenographers person to do the minute taking, and we would do at least 100 special inquiries. We've done it on 2 occasions already. The persons who we've had out on orders of supervision are really not high risk, and they tend to be persons who may have simply overstayed their time and the process for that. And it depends, because there could be different reasons for them overstaying their time. Some of those persons we will not put before a special inquiry officer, because under the legislation, the chief immigration officer can determine if the person will appear before a special inquiry officer, depending on the case. Some of them, we may simply give them or allow them to leave the country.
You see, the problem I'm having is that, you could correct me if I'm wrong, most of the cases are actually illegal entries in Trinidad, and the maximum imprisonment for that is about 6 months, I believe, a fine, or an alternative 6 months. Now, the only issue I'm having is that whether or not these persons who are detained at the center, whether they stay for a period of over what they would actually be sentenced to. Had that happened in any instance?
I'm not sure what you're referring to. And in terms of overstayers, we don't prosecute overstayers.
No, what I'm saying is that if the maximum fine for X offense is 6 months.
No, it's not 6 months. It depends on what it is. So if it is an offense, illegal entry carries a fine of $50,000 or 3 years imprisonment.
3 years, okay.
Right? That's for a first offense. For a second offense, it's $100,000 or 5 years imprisonment. So it's not 6 years, 6 months.
Okay, I'm corrected. But are there any instances of persons staying beyond what would normally be imposed on them?
It can be, but it depends, again, on the level of cooperation. So, for example, and we would have indicated to the committee that one person would have been there for 4 years and 8 months. In 2014, we attempted to repatriate that individual, and we had chartered an aircraft for his repatriation. Just before he was actually boarded, he applied for asylum, so he could not be repatriated. Because he had to go through the refugee status determination process. His application was refused. He appealed. It was again refused by UNHCR. We attempted a second time to repatriate him. He did not want to cooperate. In fact, when they got to the airline, he started acting up and he was refused boarding. And earlier this year, we again attempted to repatriate that individual, and he filed an injunction on the day before he was to board the aircraft. So that matter is still ongoing. In fact, that person is now in prison because he has been charged for false imprisonment. So there are a number of situations, and it's really on a case-by-case basis that we deal with these matters.
Senator Mahabir.
Thank you very much, Madam Chair. I visited the Immigration Detention Center, and I spoke to detainees from West Africa, Venezuela, a few other countries. And I was struck with the Madam Chief Immigration Officer with the notion of the security bond. One of the detainee from West Africa who follows the Parliament channel very closely, chatted with him and so on. I thought he was a reasonable sort. I'm simply wondering whether, if someone were to post a security bond for that individual, whether it would be relatively easy for him to be released and to go through whatever legal channels are available to him? Or is it that there are issues with the actual posting of a security bond?
Well, the posting of the security bond is only one aspect of it. And the risk involved with the particular individual, I'm not sure which one it is, so that I can probably give you the background of that person's detention. It could be for a criminal offense, and if it was a criminal offense, then certainly he would not be released. So there are a number of issues. So
I need to interject. Barring, we understand everything about criminality. Once you have broken the law and you have committed a criminal offense, a lot of your rights have been suspended. Someone has simply violated the immigration laws of Trinidad. He is at the IDC. He has no criminal record, except that he has violated the immigration laws of Trinidad. The question is, with respect to the security bond, is it a straightforward issue where someone in Trinidad who is willing to post that bond for him, the value of which has been determined by your office, can post it with relative ease and the person can be released?
Yes and no. Yes, in that once they post the bond, once the person, whoever it is posting the bond, is given an undertaking that they will be supporting the individual once they have a place to stay and everything else, certainly we can release that person on an order of supervision, all things being equal, right? If it is, it's not simply a question of posting the bond. It's the other things that go with it that, like I said, the circumstances surrounding his arrest and detention and whatnot, and that's where the no will come in. From time to time, the officers in the enforcement unit will go back through the listing to see if anybody is willing to post a bond. Some people say, yes, they will post a bond, and when the time comes to actually post the bond, they don't. Right? So we can, and if somebody comes forward and say, yes, I'm willing to support this individual, I'm willing to post the bond, I'm willing to support this individual while they're here, this is where they will be staying and whatnot, then certainly we can consider releasing that person on an order of supervision.
Question on that. I spoke to an individual who says he has a child in Trinidad and Tobago. I don't know whether he was officially married, but that he has a child. What is the policy of the immigration department with respect to keeping the family intact? Is there any consideration at all that special considerations will be given if a detainee has a child or children or has a companion or is married? What are the avenues available to him or her when to be released?
Again, it depends on the circumstances of his detention. We try as far as possible with those persons who have families, especially small children and whatnot, to try to release those persons on an order of supervision. Of course, the onus is on that individual to prove that he is, in fact, the father of the child by way of the birth certificate and whatnot, right? Depending on what the circumstances are relating to his particular case, right, he may be detained. More often than not, we try to release those persons once they can post the bond, once the companion, the spouse, or whoever it is willing to support them and can show where they are able to support them. So again, it depends on that particular case.
Madam Chair, just a last question on this. Notwithstanding criminal offenses, I understand that there are criminal issues involved that will prevent you from making any order with respect to release. The final follow-up I have on this is whether the security bond, because I imagine repatriation to West Africa may require a security bond of maybe $40,000, whether the immigration department will accept a bond posted by an organization as opposed to an individual. If an NGO were to say, we are willing to post a bond for this person, will you accept that posting as bona fide?
Yes, and we have done it before. So once the bond is posted by any individual and organization, once it is there, then, and they give that undertaking to support the individual, then yes, we can release on an order of supervision.
Just a quick question on clarifying the order of supervision. Is that valid for a particular time? What exactly is the process? Can someone exist in our country for many years under orders of supervision that keep being renewed? What is the exact process?
The order of supervision really is during that period of time when that individual is going through that process of us determining whether they are deportable or not, and the actual removal from the country thereafter. So it's intended to be a short-term arrangement where they will report to immigration, whether it's every month, every week, or whatever is the consideration for that particular individual. There are some persons who have been on orders of supervision for a year, 2 years. And again, that depends on the circumstances of that particular individual's case. There are some persons who have filed for judicial review and whatnot, and those persons remain on orders of supervision until such time as the judicial review matter is determined by the court. So you find that those persons could remain on an order of supervision for a very long period of time. So it just depends on the circumstances of that particular case.
And just one further clarification. There are two types of illegal immigrants, if I'm understanding clearly. People who entered illegally and those who overstayed their time. So that's two basic broad categories?
Yes, and I would say there are two types, or everybody who's in breach of the Immigration Act is an illegal immigrant. Somebody who has overstayed their time, they fall into that category and can be deported, right? So it just depends on which section of the law they're in breach of. Some of them carry, under the offenses, a higher penalty. Some of them, for example, working without a work permit, carries a smaller penalty of $1,000 or however long the magistrates decide that they would give an equivalent time in prison. So once they're in breach of the act, so there are a number of things. One, there's illegal entry. One, there are also persons who are producing fraudulent documents, tampering with a document. There are those who have overstayed their time. There are those who might have applied for work permits or applied for permanent residence. It is not granted, and then they simply disappear. They don't leave. And then, of course, they fall into that bracket of overstaying their time in the country. So yes, there are broad categories, but there are little peculiarities inside of there for all of them.
All right. And if I'm understanding clearly, those who are generally given orders of supervision, maybe those who would have overstayed their time because they would be able to produce documentation, ID, and so on, and to be supported. And those who enter illegally, the ones that enter without any documentation especially, are those the ones who would generally be detained at the Immigration Detention Center?
More often than not, yes. Now, even with the persons who have overstayed their time, the consideration is where they're staying, how are they being supported, have they been working illegally? So that would be some of the considerations. Do they have the opportunity or the wherewithal to post the security bond? So even with the overstayers, there might be some of the overstayers in detention because there might be a risk there. There are a number of persons who we've put on orders of supervision who have not reported to us and have just disappeared. They may be still in the country. They may have left illegally. So that's one of the risks when we put somebody on order of supervision, whether or not they will continue to report to us during that period of time on the date that they are to report to us. So it just depends on when they assess the risk, whether or not they will release them on an order of supervision.
The delegates from Living Waters wanted to make a contribution here?
Just to note that we do have some asylum seekers and persons of concern in our community who are also on order of supervisions. Yeah.
Okay. Senator Hussain?
Living Water, question to the Living Waters. You said that there are asylum seekers on orders of supervision. If I'm understanding correctly, persons who are placed on orders of supervision are in breach of the Immigration Act in some manner, right? Persons who seek refuge in Trinidad and Tobago, why are they placed under orders of supervision?
That's right.
I think I'll have to take that one.
Okay.
The fact is there's no laws in Trinidad and Tobago to deal with asylum seekers and refugees. And the current Immigration Act does not cater for asylum seekers and refugees. More often than not, the asylum seeker is in some way in breach of the Immigration Act. They may have entered illegally, they may have overstayed their time in the country, and therefore, the only way for us to release them from detention would be to place them on an order of supervision while their refugee status determination is being conducted by the UNHCR.
Well, Trinidad and Tobago, we are signatories to the 1951 Convention on Refugees. And I read Article 31 that states that the contracting state, which is Trinidad and Tobago, shall not impose penalties on account of the illegal entry or presence on refugees who coming directly from a territory where their life or freedom is threatened in the sense of Article 1. So is it that we're not complying with our international obligations pursuant to Article 31 of this convention?
Well, we are signatory to the convention. We have not brought any laws. We have not brought that under the domestic laws of Trinidad and Tobago. So while we have started since 2014 to address that issue, and we have been working closely with Living Waters community and UNHCR to put measures in place. There is a draft policy which is currently being reviewed. There is draft legislation which is also currently being reviewed. So steps are being taken. However, there is still no domestic law specifically to treat with those individuals. And it is because of that article in the convention, which is why we've had to find a way to release them from detention. So just saying that they have an asylum seeker certificate and, okay, yes, they're walking around with this, does not protect them really. So that it is a matter that is being addressed. We have all identified some of the issues. We have had standard operating procedures. We have regular monthly meetings of all of these stakeholders to address some of the issues. So for us, from immigration, dealing with these persons, there's nothing in my legislation that I am charged to enforce that really caters to asylum seekers and refugees who are in breach of the legislation.
My only concern is that, well, Trinidad and Tobago, if there are no domestic legislation, we should be guided by our international obligations. And if we are signatories to the treaty, why are we not enforcing these provisions of the articles? Because as far as I'm aware, we have no reservation with regards to Article 31.
Granted, but at the same time, I am bound by my Immigration Act. And therefore, I require something a little higher than me in order to move forward. But like I said, we have been meeting regularly, all of these stakeholders. We have gotten to a point where there's draft legislation, where there's a policy that is being reviewed by government, and therefore steps are being taken to address the issue. Like I said, from where I sit and being bound by the Immigration Act, sometimes I find myself between a rock and a hard place. But in order to give effect to the convention and to ensure that we are not in breach, we have tried to apply the provisions of the order supervision to ensure that they remain in the country so that if they are stopped anywhere, then they can produce the order of supervision. Not everybody is on the order of supervision, and there are challenges that we work with Living Waters community and UNHCR to address those issues.
Could I ask, in the context of what you just read out, there were provisions, though, with respect to who should be included in that, in terms of in fear of life and so on. If I may ask of the legal officer from Living Waters community, how is that determination made with respect to, because we can't be in breach if the person is not in fear of their lives or that kind of, is not war or that kind of circumstance. How then do we look at ourselves in terms of whether we are in breach or not? Because we are only in breach if we put people under restrictions when they come from countries where there's war and there's fear for their life or something like that. What is your view on that?
Well, an asylum seeker, just to reiterate the definition, is someone who's fleeing from a country where their lives may be in danger or they have a fear of return. The 1951 Convention, as Mr. Hussein mentioned, protects persons of concern from non-penalization with regards to illegal entry. But due to the fact that Trinidad and Tobago does not have any laws in place to protect these refugees, and using the Immigration Act as legislation to guide the laws, there is that sort of discrepancy in terms of trying to meet our international obligations. But as Mrs. Charmaine Gandhi Andrews mentioned, we are working together with the draft legislation and our monthly stakeholder meetings to ensure that these persons of concern who do enter illegally and who are asylum seekers are afforded some sort of protection mechanism.
Mrs. Shannon-Smith?
I want to go back to the treatment of the detainees at the IDC, because on our visit there, we were bombarded with a lot of issues that the detainees were experiencing. And I want to ask, what mechanism is in place, or what procedure is in place for a detainee to have an audience with a member of staff for situations when they want to find out their positions? Because I realize that some of these detainees, they are there for over 2 years, and they don't have an understanding of what's happening for them. They don't know what's the next step. They don't know how they can access information as to their status in there. I want to know, do you have a process or procedure, especially when you have females detainees? Who do they speak to? And how does it happen? Could you explain it to us?
Thank you, Member, and through you, Chair. I just wanted to say I'm going to ask Mr. Ailey to comment on that question a bit. But before Mr. Ailey comes in, I just want to state that we've discovered that a lot of what we understand would have been said to members of the committee by detainees. I want to place on record that some of those things, a lot of what has been said, isn't really true. It's really not reflective of the situation at the Immigration Detention Center. And so I think I want to ask Mr. Ailey to comment on the question and to respond to the...
Just before Mr. Ailey responds, I want to just make it very clear that when the committee goes on a site visit, we would have a lot of information coming to us from different sides, from the sides of the administrators, as well as from the sides of the detainees. And that is the purpose of us coming here, to clarify some of these issues, because truth is a subjective thing. The view and the reason why we go to the site visits is because we want to see, we can sit here and speak, but when we go there and we not only hear from the inmates, but we make observations, it further informs on what we have been presented with at the start. So I just want to make that clear, that when we go out and submissions are made to us, especially from a situation of detention or if it's a prison and so on, our remit is not necessarily to accept anything as truth, and that's why we investigate, we ask the questions to get to the bottom of the issue. So I don't want it to be presented as though we are taking anybody's word for truth. What we are trying to do is to flesh out all of the issues so that we can come to some determination in our recommendations for the report. All right, so I just wanted to say that before Mr. Ailey gave his comment.
Thank you, Madam Chair. The procedure is the detention supervisors, they would make a list of the names of the detainees who has issues, all the issues. They would have it on a list. They would come to me daily. I would personally interview them, in some cases they need a phone call, or they need to just inquire about the status of their immigration status. What I would do is communicate with Port of Spain, in the enforcement unit, because they would have all the information, the files and so forth. And in some cases, the list is very long. So what I would do, like on Saturday, I would set aside a Saturday and go into the center, listen to all the inquiries, listen to all the concerns, and then I would forward those concerns to Port of Spain for feedback.
if I may, just to follow up on this question, I'm sure Mrs. Jennings-Smith has some other questions on that. When you said you set aside a Saturday, it sounds almost like an informal arrangement. And it reflects the general feeling of what was said by quite a number of the persons there. Is there a case officer that deals with a certain number of people that they can refer to get regular updates? Is there a set time and procedure? If I understand correctly, there should be an immigration officer available every day. Is that person you at every time? Is there a particular time of the day? What are the actual structures put in place for this?
Okay, well, we have we have immigration officers who are rostered for duty there from 6 a.m. to 7 p.m. They are junior officers. The detention supervisors would again inform them that a detainee requires some information. I, as the most senior officer, would inquire what the problem is. If I can help, I'll take the information from them, and then I will contact the investigation in Port of Spain on a daily basis. That is on daily. So I try my best to see detainees daily so that I can get to give them some resolution to their matters.
And exactly, you're taking me right where I want you to be. That reference you're speaking about Port of Spain, every time you speak of a person's case or an issue, you refer to Port of Spain. And that was a concern we had when we were up there, that information was not readily available. For example, if John Brown had a problem and you wanted to find out more about what's going on or what is his status, you had to call Port of Spain. What plan is there in place to have information readily available at the Immigration Detention Center?
Chair, if I may. The enforcement unit at all times communicates with the detainees, advising them what are their charges. They produce documents to them, they're ordered to show cause, outlining all of the challenges, all of the immigration infractions. And they would also tell them what is the date for their special inquiry. A lot of the times, the detainees themselves, after the whole procedure, let's say they go before the special inquiry officer, their matter is determined, they're either given voluntary departure or they're ordered deported. The next stage after that is the purchase of a ticket to leave. During the special inquiry process, they are asked whether or not they can purchase a ticket to leave or whether they require the state to purchase a ticket for them. At the inquiry. More often than not, they say, no, my family will buy a ticket for me, and we would await that. They would then say yes or no, they can't buy the ticket for this month, they could get it next month, and whatnot. I've instructed my officers that after 3 weeks, if no ticket is provided for them to leave at the end of their special inquiry process, that we will approach the permanent secretary to purchase a ticket for their departure. And they are always informed of that by the officers in the enforcement unit, because the officers in the enforcement unit are the case officers for all of the detainees. They're all assigned once they are detained. Those officers in the enforcement unit are responsible for them from the time they are detained and interviewed to the time of their repatriation. Any detainee who wants to see anybody, they can either be brought to Port of Spain on a daily basis, because every day, as I mentioned, detainees are brought to Port of Spain for a special inquiry. They can come, they could make inquiries as to, well, what is the position with their ticket? Well, we've written to the permanent secretary to get the ticket. As soon as we get the ticket and the date, we will advise you. So it is not so much that the officers are not informing them about their matters, because when they get in, once they are detained, they are given a letter that states the reason for their arrest and detention, whether they are to go to court. They will let them know the date that they are taking them to court. They are all asked whether they want an attorney present. So there are times when they may think that it's a long process, or we're not getting enough information, but there's no information to give at that point in time because it is either they have already been given the date for their special inquiry or we are waiting a ticket for their repatriation, either from them or we are waiting the approval from the ministry to purchase the ticket for them. So when they say they don't get enough information, sometimes we wonder, well, what other information they want except that this is the date that you're going to depart. We are waiting this matter, they are waiting the ticket, and some of them say, well, no, my family can't meet me on that date, so could you put it off for another day? So there are different circumstances for all of them. Granted, there might be some of them, and I'm not saying that maybe some of them get no information, and if they get no information, sometimes it's because there's no information to give from the last stance. We are waiting sometimes travel documents from their embassy, some kind of identification document for them before we can move forward, even with a special inquiry. So there are different circumstances for each case in the detention center. And the officers are there all the time if they have a request, if they want to make a telephone call, if they want any information. They can, in fact, the officers in the detention center will pick up the phone and call the enforcement unit to find out what is the circumstances, right? So there are a number of things that will take place. And there are a number of circumstances. It just depends on each case.
Minister Hossain.
Thank you very much, Madam Chair. Ms. Maraj mentioned a while ago about asylum seekers. Are we currently holding any asylum seekers as detainees, and what is the plan for their release?
Sometimes we don't know that they're an asylum seeker. A lot of the times, only when they get to the point of appearing before a special inquiry officer, that they suddenly produce an asylum seeker certificate. We've been trying to work with Living Waters community and UNHCR to ensure that at all times we know if there are asylum seekers at the detention center. Again, it depends on the circumstances of the case. If the person has to be charged for whatever offense, then they will not be released from detention, and it depends on what that breach might be. There are some of them who are in detention for having been convicted of criminal offenses. They have applied for asylum. Those persons will not be released. So again, it depends on the circumstances. More often than not, when we are notified that this person is an asylum seeker and they can be released after they post the bond and whatnot, we will release the asylum seeker. Again, it just depends on the circumstances of that particular case.
This is a sad question I asked a while ago. Your records and information, for example, if one were to ask you at this one point in time, do you have any asylum seekers at the detention center? Can you answer that question? Can you tell us how many?
I do have the list here, and we have a list that is updated daily.
So if you have it, could you, if you have it there, could you say it?
I have to go to the 100.
Is it quantified? Like, well, what I mean is that if do you every week give a summary of what's happening there? That you know, and we found that as an issue because every time a person brought up something and we asked an immigration officer present there, he was saying they have to call Port of Spain. They have to call Port of Spain to get, and I'm referring to the comments of Mr. Ali when he said that, you know, there are so many issues to deal with that he leave off a Saturday. So that I want to, you know, just in my mind, I'm thinking you are going there on Saturday and you are seeing 10 or 100 people. So when you're seeing those 100 people, how do you get the information to speak to them? Do you get the information beforehand and come and have those interviews with those 100 people in reviewing those cases? Because that was a main concern, your records keeping. How do you manage it? How do you update it? So you could get, you know, up-to-date real-time information for persons who are there, not as prisoners, but are detained.
once we get the information from Living Waters community or UNHCR advising us that these persons are asylum seekers and they are in possession of asylum seeker certificates, because we have set up an ad hoc refugee unit that liaises all the time with the Living Waters community, and they are also part of the enforcement unit. So that information, once we have it, they will liaise the refugee unit with the enforcement unit, the officers there. These persons have asylum seeker certificates. Again, they will go through their files to determine if that person can be released or not. So if they can be released, they are released. If they cannot be released, then they remain in detention.
Comments of Living Waters on the same issue, to comment from that side as well.
Okay. Well, I just wanted to clarify one thing. So we have asylum seekers who are registered. Those are the persons that would have filled out the refugee status determination form, submitted a formal application, and would have had a certificate issued. Then there may be asylum seekers at the detention center who are not registered, but may be seeking asylum. And one of the concerns we would have had is if these unregistered persons were able to speak to an officer at IDC to declare that they are seeking asylum, and if they're, because I know there are interpretation challenges, especially with language barriers, if there is someone who can understand them in their language to note that they are seeking asylum. We have seen where persons, so we do send regular lists to immigration of persons who are registered, persons who have been detained, and we have seen cases where they would be released once immigration receives that information. I can't exactly state the length of time, but it varies from a couple of weeks to a couple of months. I believe at times shorter periods. But yeah, our main concern would be for the persons of concern not registered, and do they have the ability to say they are seeking asylum to an immigration officer there, and how that is dealt with subsequently.
Could you just elaborate when you say that's your area of concern? What exactly has been the experience, or is there a particular recommendation you'd want to make that would assist in that gap being closed? Those who want to become registered and may have difficulty transmitting that and getting the meetings to get that process going forward.
Well, I can't say for certain if persons have done it at IDC and if a process was followed, but one of the recommendations that we would like is better access to IDC, so at least we can interview these persons themselves to know if they would like to register as asylum seekers.
How do you usually get access to IDC?
Currently, we don't have access to IDC. We've had, I believe the last time we were actually able to go there was December 2014. We had one successful visit this year, but there is a process where if we can't go to IDC, persons of concern will be brought down to the enforcement unit at Henry Street, but the responses in terms of this process happening on a regular basis has been varied.
So does the LWC usually write and ask for to come in on a certain day to speak to detainees?
We have not written regularly. We did make one request this year, but that wasn't facilitated. However, UNHCR during the year have been able to secure some visits, not at IDC itself, but having persons of concern brought down to Henry Street Immigration.
Maybe PS or Ms. Gandhi Andrews, what exactly is happening with the regularity of the access to detainees with IDC?
First of all, we agreed some time ago on what would be a standard operating procedure for persons seeking asylum. And any person, whether in detention or otherwise, can approach an immigration officer and say, I am seeking asylum in this country. And there is a process that kicks in right away once that person indicates that they are seeking asylum, that they are, and in this case, I mean, the definition of asylum seeker is not just that they're in fear of their life and limb, but they are in fear of persecution. And that is the determining factor, and there are 5 grounds for the persecution. So once that happens and they declare that they are in fear, they have a well-founded fear of persecution in their home country, they are seeking asylum in Trinidad and Tobago, right away the officers will contact the refugee unit. The officers in the refugee unit who have been trained will interview them and they will refer them to the Living Waters community for registration. Now, there's a difference, as Gina would have mentioned. There are those who are unregistered asylum seekers, and for us, until you are registered as an asylum seeker, then we would not really, at that point, deal with you because there's a process, even with that, with UNHCR, you declare your intention to seek asylum, whatnot. There's a process that they go through to be registered by UNHCR, and they are then given an asylum seeker certificate. But anybody can approach an immigration officer or a detention officer. There are detention officers who do speak a foreign language at the detention center, and they communicate with the detainees. A lot of the times what we have found out is somebody approaching Living Waters community on behalf of somebody who is in the detention center. So the detainees themselves are not coming forward to the officers saying that they are applying for asylum. So we do not know until after the fact that that particular detainee is applying for asylum. As I mentioned earlier, sometimes it is only at the point of the special inquiry that the person will produce maybe a copy of an asylum seeker certificate that was sent to them. And we then have to verify whether that asylum seeker certificate is authentic and was issued by UNHCR.
So if I could just focus on the standard operating procedures that you would have agreed on. That is triggered by the request of the detainee. So is any accommodation given to a request that comes from Living Water to visit? That's not the way it operates.
That's not the way it operates. A person, if you are in fear of persecution,
so to Living Waters, this is what was agreed on? Sorry. Those operating procedures?
Yes, those operating procedures were agreed on, but a person can also voice their concern to Living Water community that they wish to seek asylum, because if the person declares an immigration officer, immigration would refer it to the refugee unit, and refugee unit would refer the person to us. Same instance, if they declare to someone from UNHCR that they wish to seek asylum, UNHCR will refer the person to us because we are the first point of contact. The process is called reception for asylum seekers. We actually, at one point, well, for a long time, conducted the actual registration, but now that process is being moved over to UNHCR. But we are the reception of these asylum seekers.
So is it then that based on the procedures agreed upon, Living Waters would also want to include in those procedures access to the detainees?
Yes, Madam Chair.
Has that been discussed, and what has that been agreed upon?
No, we have discussed it, but we haven't come to a conclusion as yet in terms of that.
And I'm saying this, I'm asking this because in the submission from Living Waters, what comes across is that they would like more access, and that is not being given. So I'm trying to get to the bottom, but if there are standard operating procedures that were agreed upon, it means then that it is not as though access is not being given, but we agree to go a certain way. But if there is now request for revision of those operating procedures to include access of living waters to detainees without them having to ask for or saying that I am seeking asylum, is that something that can be considered or will be considered by the Immigration Division?
Madam Chair, when we detain somebody, there is every opportunity from the point of detention for an individual to state to any officer, I am in fear of returning to my home country, even before they get to the detention center. So the question has always been, is it that living waters, and this is the discussion that is ongoing, is it that you want to interview every single detainee to see whether or not they are whether they want to apply for asylum? I don't know that that is the actual process or if that is what happens everywhere else. Because it is an individual making a claim, I am in fear of persecution. And that person declaring that to whether it is to the authorities, whether it is to Living Waters community, and whoever it is. But there is ample opportunity for the person at any point of the detention process, from the time we interview them, because during the interview, when we detain anybody, we screen to see if that person may be a victim of trafficking, and they are also asked whether or not they are in fear of returning to their home country. Even at the special inquiry, that is a standard question for the detainees, that person appearing before the special inquiry officer, are you in fear of returning to your home country? If the person indicates, yes, I'm in fear of returning to my home country, the special inquiry at that point is adjourned right away for that person to be interviewed by either the refugee unit or being referred to Living Waters community. So there's a process. If it is agreed at some point that Living Waters will have free access to the detention center, and I don't think that decision will be mine, free access to the detention center to interview persons to see if they are asylum seekers, then I think that's a different conversation that we have to have, bearing in mind that there are no laws in Trinidad and Tobago. And those are the things that we have. So even if they apply for asylum, even if they are recognized as a refugee, the issue is what happens to them thereafter and what kind of benefits, because they're not allowed to work. There's no work permit requirement. There's nothing that we can give to them. So they're really in limbo at all times. So there's a process that we follow all the time. Like I said, if it is they are to be allowed to go to the detention center to interview persons, to all of the detainees as to whether they are in fact an asylum seeker, then I think that has to be a decision elsewhere.
Madam Chair, thank you very much. I have a follow-up on this. You see, Madam Chief Immigration Officer, you're saying if Living Waters is allowed to, as if it's a favor that is being given to an organization. I have visited a maximum security prison. I have visited the IDC. The IDC, in my mind, is not what you will consider a maximum security prison where you have all prison protocols in place. I actually mixed and mingled in the huge holding bay with a great deal of the detainees inside there. What I'd like to find out is this. In the interest of human rights, I know we have all the operating procedures and the laws and so on. In the interest of human rights, I have two submissions before me. One from Living Waters, one from UNHCR. They have both indicated access to IDC remains a challenge for the Living Waters committee, Living Waters. Staff have not had official access. Clearly, you have an organization that is looking after the interest of the detainees that would like to have more access. And the question I'd like to pose is this. In the interest of human rights, I am of the view that if they ask for it, they should get it. What are the impediments? You say it must come from above, but clearly there are certain issues which would have to be worked out by the administrators themselves. Is it that you have a minimum amount of staff that you could allocate to supervise the visits? Is it that you don't have the appropriate rooms? Is it a funding issue? Is it a security issue? What prevents the IDC from having a procedure which says when the UNHCR, which UNHCR said that they weren't able to visit since 2014, what really must be done to ensure that agencies with an interest in protecting the human rights of all people have access to the IDC?
Is it access to the IDC or access to a specific individual? And I'm sorry if I came across as if we are granting them a favor. It is certainly not my intention. Because anytime a request is made to see a specific individual, we make all of the arrangements for Living Waters Community or UNHCR to visit those individuals. The question for us is it blanket access for them to interview every person in the detention center? And that is what has to be determined. Because once they say that they wish to see any individual, we make arrangements. A room is set aside either in the visitors area or another area within the detention center for Living Waters Community or UNHCR to interview those individuals. There are times when the situation at IDC can be particularly volatile. And what we have observed over the last year or so is that anytime an external person goes into the detention center for whatever reason, that the detainees themselves start acting up. So that there's a security issue inside of there. And that has to be managed and controlled. So that it is not a question of us denying anybody access to the IDC. It is the purpose of the access. And if it is that they have a list of persons, and they do give us a list from time to time, we've had these persons who we would like to visit, we will determine whether it can happen at the detention center or whether for safety reasons we will bring them to the Port of Spain office where they can be seen by UNHCR and Living Waters Community.
Okay, a follow-up on this. You see, as my colleague Senator Hussein indicated, we are signatory to the 1951 Convention. Clearly, Trinidad and Tobago is not the only country in the world or even in the region which is dealing with this issue. Have you looked at operating procedures in other Caribbean countries? Have you looked at it across the world? Have you taken advice from the International Diplomatic Corps that's here as to how they treat with this issue? Because clearly, if UNHCR is telling me that to date, UNHCR has only been able to visit twice the IDC, they are telling me that they perhaps made attempts and they have only been able to visit twice. And perhaps in other jurisdictions, they have had freer access. Have you looked at how other people do the thing? I know this is the first time we're handling this issue in Trinidad and Tobago. We don't have too much experience. But what does international protocol tell us is best practice in this area for UNHCR and the sub-agencies like Living Waters to have access to your detainees?
Within the region, we have been having regular meetings. In fact, we launched what is called the Caribbean Migration Consultations with different migration agencies within the Caribbean region to address this particular issue. And we've met so far twice. We launched in 2016, and it was launched in Trinidad and Tobago. And we met last year in the Bahamas to discuss specifically refugees and how as a region we are to treat with it, because we are all actually in the same boat. We've had the experience of the Cayman Islands. They have a established procedure dealing with refugees, and they have outlined some of their best practices. And we are all working with some of the best practices and coming up with solutions as to how we should treat with the issue. So that is an ongoing process. In fact, some of the other countries are looking to Trinidad and Tobago because we are further ahead in our deliberations and our working arrangement with Living Waters Community and UNHCR to establish proper systems, because we have shared our standard operating procedures with the other islands. In fact, the Bahamas has recently developed a document that they are going to share with the rest of the region as to how they plan to treat with asylum seekers and refugees. It is an emerging phenomena, if I wish to call it that, I'm using that loosely, in the region. We've not had to deal with this before, especially in these large numbers now with the situation right next door. So it is an ongoing process, and a lot of it has really to do with government policy and the establishment of those policies, those laws to treat with the issue. Because from where I sit, as I said, I am constrained by my law. And while I have in the past allowed certain things to happen, I am actually running ultra-virus to my own Immigration Act. So that there are things, and I'm admitting that publicly, but in the same interest of human rights, that we have tried to deal with the issue. So it's a large issue, and it is something that is emerging in Trinidad and Tobago that we have to deal with. There are probably close to 7,000 from the last report from UNHCR, asylum seekers in Trinidad and Tobago. So that it is a problem. The detention center is only one small issue, but you have more persons on the outside who really are in limbo because there is nothing in place as yet, and it is something that has to be addressed. When it comes to detention, there are particular issues, and like I said, there are security issues with the detention center. If the persons, UNHCR or Living Waters, anytime they tell us they want to see these individuals, we make arrangements for them to see those persons.
Okay, if I may, just to clarify, I would like Living Waters to come in and to clarify exactly what access you are speaking about. Is it do you have difficulty accessing individuals that you have asked to access, or is it that you want to be able to come in and address the detainees in a general manner to advise them of what their options may be? Maybe we could have some clarity on you from that, and as well, maybe you could weigh in on the issue of regional practice and international best practice, and whether or not this is something that is followed internationally or regionally.
Well, just to clarify, we are not asking access for all persons in detention. We're just merely requesting access for those persons who would have indicated that they wish to seek asylum, maybe through family members, maybe through friends, locals in the country, just to follow up, because as indicated, everyone has a right to asylum, and it is our duty as Living Water community, implementing partners of UNHCR, to ensure that these persons of concern are protected and are given a fair opportunity to apply for asylum or to ask any questions they might have about the process. So this is the type of access we're requesting, and we have data of persons that would have reached out through third parties stating an intention to seek asylum, and if we are granted access, we would have a list of names that we would want to interview particularly, so it wouldn't be for all persons in detention.
So let me just be very clear. What you're saying is that there are persons who have not, detainees who have not said to officers, who may not have said to officers that we want to seek asylum status. However, they have said it through third parties, and you are having difficulty accessing those persons.
Yes, correct.
Even though you have tried to get onto them.
Yes, correct.
Okay, so I just want to be clear that that is what we are seeing. And in terms of international best practice.
I would just add, Madam Chairman, that what happens is that in terms of asylum seeking and refugee status and all of that, the asylum seekers' circumstances may change in terms of their country of origin. So at any point in time, their local circumstances, their local condition at their country of origin may change. So therefore, they may be entitled at any point in time to make that application. It may not have been relevant last year, but it may be relevant now.
And
Mr. Hossain?
Thank you. Seeing that there's a large population of detainees at the IDC, has any voluntary repatriation exercise carried out in the center to determine whether or not any of these persons would like to return home?
I'm not understanding the
For persons
question.
who seek refugee, a person who seeks refugee does have a right for voluntary repatriation. Again, under international law, the human rights that are endowed on them. Has any exercise been conducted with respect to those persons who would be willing to return home?
For us, anybody who is willing to return home will be facilitated. If you're talking about a refugee who has decided to return home, there is a process for that individual that UNHCR has in place in terms of advising them and whatnot, so that it does not appear as if the country is breaching that whole principle of non-refoulement. So, but anybody could return home. So it's not an issue of them returning home, it is the question of who pays for their repatriation. The only time that we will pay for their repatriation is if we have ordered them deported. Otherwise, they are required to produce a ticket, however they acquire the ticket.
Has Living Waters had any issues with regards to this?
Well, generally speaking, once a person has an asylum seeker certificate or refugee certificate, in principle, they are not supposed to be refueled to their country of origin.
Just a question on the deportation order issue and some clarification I think the public would be interested in knowing. Someone can have a deportation order and still be at the Immigration Detention Center. Could you explain to us how that happens and what are the circumstances under which that would occur?
The reason why they'll have the deportation order and still be at the detention center is that we are waiting either the ticket for them to return home that they are willing to provide, or we are waiting approval from the permanent secretary to purchase a ticket, or we are waiting the cooperation of the detainee themselves after they've been ordered deported to actually leave when we've made arrangements for their repatriation. Because like I mentioned earlier with one of the detainees, we made arrangements for his repatriation, had all of the escorts in place, bought tickets, everything is arranged, and 2 o'clock in the morning he serves an injunction saying that he's not going home, right? That he has some legal challenge and he does not wish to return. So we've had to abandon that process. So we get to the point of ordering the person deported. The next stage is the actual repatriation, the removal to their home country, which requires the ticket, which requires the travel document, and the escorts, and then that detainee cooperating in their repatriation. We've had detainees get on board the plane and then decided to act up and were removed from the aircraft. So that whole repatriation exercise was aborted. So that's the reason why they would hold a deportation order and at the detention center.
Mr. Jensen?
Yeah, I want to return to an earlier question because I believe my colleague here had asked about and you referred to him about the 6 months as nothing or not being applicable. And I want to return to the fact that the International Organization on Migration submission to the Working Group on Arbitration and Detention published in November 2011 said that a maximum period of detention must be established by law, and this may in no case be unlimited or excessive in length. And the European Union Directive 2008-115 stated and recognized that each member state should set a limited period for detention, and the period cannot exceed 6 months. So, yes, I know that even Living Waters, they accede to the fact that you all have been agreeing or working out something to present for law. But, you know, sometimes when we set limits, it gets us to be more effective and efficient, and it would have had an impact on how long we have the detainees at the center and how we would treat them to have them dealt with in a more quicker timing. So even though you all are working on something, and bearing in mind that we have an European Union directive which states that the period should not exceed 6 months, did that impact upon your determination of your standard operating procedures and your practices in dealing with these the persons at the detention center? Because what we are looking at is that people have been kept there for long periods of time. And yes, we know there are other things that would have barred their release. But did that point have any effect upon your determination in developing your standard operating procedures, and your practices?
Okay, there are two separate things. The issue of asylum seekers and refugees is one issue. The issue of detention and the length of detention is something completely different. Our act does not speak to any length of detention. It speaks to detention. We try as far as possible to fast-track our processes in terms of the time for their detention, when we detain them, to the time they appear before a special inquiry officer. And like I said, once everything is in place, we could have that person removed from the country in a very short space of time. The issue with the length of detention has to do with the other factors. Can we identify the person, which is the key issue for us? Identifying the person, their nationality, because then that determines where we are going to send them to once they are ordered deported. Whether they're cooperating, do we have a travel document? So all of those things come into play. And this issue of the length of detention has come up in various court matters when persons file writs of habeas corpus, and it has been ventilated in court. There are some attorneys refer to what is the Hardyal principles, the Hardyal Singh principles, and we are also guided by that. And, but it comes down to the detainee and their cooperation, because a lot of them will, once we put limits, okay, you can't detain me for more than 6 months. And therefore, there are times when some detainees have played for a release. So after a particular period of time, they don't cooperate, and they say, well, no, now I'm going to file a writ of habeas corpus because you're keeping me in detention too long. Right? So there are two sides to that. There's one side where, yes, you can blame the Immigration Division for being tardy in processing them, but that tardiness, I wouldn't say it's really tardiness, but is in putting all of the measures in place to effect their repatriation at the end of the day, having a travel document, liaising with their embassy, getting travel, the travel document, the tickets, etc., the escorts. And that could be a protracted period of time if they have to serve time for their offense. Right? So there are a number of factors that come into play.
And I'm saying all of this because at another time when you were before this very committee, we looked at the cost factor with the keeping of detainees at the immigration center for these unduly length of time. It is really creating a lot of expenses to the government for the maintenance of these persons. And hence the reason why I suggest now that maybe you should factor that into your policy and your planning with respect to how you deal with detainees at the center, because you not only have a legal implication, but you also have a huge cost on government.
So you take our last question, maybe, from
Madam Chair, a follow-up on this. You see, what colleague Jennings-Smith indicated to my mind is a very, very practical problem that we have. I looked at the submission from the Ministry of National Security, and I saw that meals per day amount to some $80. I estimated that it may cost the state something like $300 a day when we're looking at all other costs to house a detainee. When I extrapolated that, I saw that after 6 months, the 6-month period that my colleague suggested, we would have spent something like $50,000 to house a detainee at the IDC. And given that it was earlier indicated that a security bond posted to say one of the most expensive destinations may not exceed $50,000, I am wondering from the policy-making perspective of the Ministry of National Security, this may very well be directed to the PS Ministry of National Security, whether, given the fact that after 6 months at the IDC, the amount that we are spending to house may be in excess of the amount that we are going to spend in repatriation, whether you shouldn't have some policies in place to ensure that the systems of detention can in fact be worked out for the economic reasons only within a 6-month period.
Well, actually, we've looked at that on many occasions, and the issue with that is the risk involved. And the fact is that we do make every attempt to either repatriate or release detainees because we've taken the cost into consideration. And the decision to either repatriate or to detain, the Chief Immigration Officer has gone at length to describe how we treat with that. But certainly we do take into consideration the economic factors in determining the measures we take at the detention center.
But Mr. P.S., if someone is willing to post a security bond for that individual, maximum, say, 50,000 within a 6-month period, do you think that that particular process can work to make sure that we minimize the stay at the facility? If we can encourage people to post security bonds for people on the inside?
Well, that could be so, given the other factors. Yeah?
So we will take 2 more questions. We will take one from our online viewers, and we'll take the last question from Senator Hussain. One viewer is asking, how are persons repaid their bond, imagine their security bond, once they leave the country, especially in instances where they also have to pay in addition for their ticket back as well as the bond? So they're asking, if someone has paid the security bond and they have paid for their ticket, how are they getting back their bond money? Is that a circumstance that occurs?
The security bond can be refunded. Once they produce a ticket, and more often than not, the bond is in the name of the person who's actually paying it. So it's more often than not, it's not in the name of the detainee. But for example, if I post a bond for any detainee, it's in my name, and then once the person has left the country, we actually refund that security bond. And there's a process once it's released, once the person has left, and we confirm that that person has left the jurisdiction, then the accounts unit will make the arrangements for the refund of the security bond. If it is the person is out on an order of supervision, the security bond is paid, and they then breach the terms and conditions of the order of supervision, that security bond will be forfeited. And it becomes part of the state resources to repatriate that individual when the time comes. But in that case, once the person is in breach, that money will be forfeited.
Senator Hussain?
Just, Chair, on your question, did you, I probably missed it, but did you give the process where the bond is in the detainee's name himself, how he gets back the money?
He makes a request.
He makes a, and the money is transferred to him abroad?
Yes.
Okay, and the last question I have with respect to this inquiry is, I was looking at some newspaper reports, I believe in the month of May, and there was some protest at the IDC with regards to some of the detainees actually drawing their own blood, burning mattresses, hunger strike, because of the treatment and the conditions of the center. Has anything done since May till now in order to address those concerns? Both the Ministry of National Security and also Living Waters, if there are any complaints coming out from the detainees. As to if anything has been done to alleviate the problem since May. And the second question is that to Living Waters, whether or not you have a different perspective.
Before I let Mr. Ailey tell you, because he's the person at the detention center, we would have expended significant sums of money to improve the conditions at the detention center. We've had Defense Force personnel on the ground actually doing the work, the construction and whatnot, and that work is still ongoing. We've replaced beds, we've replaced the tiles, we've improved the conditions.
Is this the period from May?
Yes. Yeah. And that has been ongoing. I think the last issue we had was with the fans and the ventilation, and that was addressed in July of this year. The riots that took place in May, I will let Mr. Ailey tell you about that because he was directly involved.
Okay. Well, basically what transpired is that most detainees, they became upset because they were asking about their status. And the answers that we gave them, they weren't satisfied with the answers. It wasn't really the conditions, because since last year, December, work started at the IDC. We improved the lighting, ventilation, plumbing. We procured new beds, mattresses. So basically, the upgrade was not the upgrade was done, so that was not the issue. The issue, as always, is their status here. Why they're being kept so long? But the thing is, we have, and what happened, they find that we give the same answers all the time, that we are waiting word on your consulate to get a travel document. We are waiting some other document. So that in May was not on the grounds of the conditions of the IDC, but other immigration status.
All right.
Living Waters.
Living Waters, you have a comment?
Oh, we can't really attest to the conditions of IDC because we don't have first-hand knowledge of it. But what I can say is that, at least for persons seeking asylum, us having access to speak with them can provide them some sort of comfort in terms of their status as an asylum seeker.
Okay.
All right, so last contribution from Senator Mara.
Thank you for indulging me, Madam Chair. And this is a question that is in relation to asylum seekers. With children, are provisions made to have the children enrolled in schools in Trinidad and Tobago for asylum seekers? Have children in Trinidad and Tobago who are not enrolled in schools and who ought to be in schools according to the laws, where everyone under 16 ought to be in school. The Ministry of Education here to answer that one. Or you don't have the information on it? Okay. Clearly, there must be a policy for the education of children of asylum seekers.
I don't know. I'm not sure. And I'm looking at the ANG. I'm not sure if this is necessarily a part of what you all would look at.
Well, Honourable Member, what we can say, at least from the Living Water community side, is that there are challenges with respect to minors, children in Trinidad and Tobago, Trinidad and Tobago asylum seekers and refugees who have not been allowed access to education. We have those registered, actually.
Challenges. Is it that you're saying that there are children in Trinidad and Tobago who may be in some housing facility who are not given the education facilities simply because their parents are asylum seekers? Are you saying that?
No, I'm not saying that.
Okay. What exactly are you saying?
I'm just simply saying that what we have happening is there are registered asylum seekers and refugee children in Trinidad and Tobago, parents who are asylum seekers as well. They are not being given the opportunity to get access to education, to public education.
I want to caution us at this point. I think we are stepping out of the area that we have intimate knowledge of, and I want us to not go into blatant speculation at this point. So, that being the case, I would like to thank everyone for their submissions and invite at this point brief closing remarks from P.S. Vel-Lewis as well as Ms. Gina Maharaj of the Living Water community.
Thank you very much, Madam Chairman. Let me just say that despite the fact that we may have no laws at this time to treat with refugees and asylum seekers, we do have a very good relationship with the Living Waters community and the international organizations in Trinidad and Tobago. As the Chief Immigration Officer said, in fact, it was under 2 years ago, under 2 years now that we've actually revised our standard operating procedure with the Living Waters community to treat with those matters. Let me also give you the assurance that the Immigration Division and the Ministry as a whole is doing everything within its powers to ensure that the conditions at the IDC are such that the detainees there are comfortable, are well served, and every effort will be made and continues to be made to ensure their human rights are observed. Thank you very much.
Thank you. Ms. Maharaj.
Madam Chair, yes, we definitely have a very good working relationship with the Ministry of National Security, and this is an ongoing process in terms of moving forward for protection of asylum seekers and refugees. I would just like to make some closing remarks because you did ask a question about international best practice, and it wasn't answered. But the UNHCR detention guidelines do recommend that the right to asylum must be respected, and detention of asylum seekers should be considered as a measure of last resort. And if you permit me, I would just like my colleague Alison to just comment on alternatives to detention.
We mentioned in our second submission that the European directive to which Madam Vice Chair referred, that it's at 6 months. In fact, Cabinet issued a draft refugee policy in 2014 which established 10 days as a limit to detention. Other best practices we can look at abroad include the Philippines, where refugee applicants are released provisionally, and Sweden, where detention is only used as a very last resort for persons being deported. In Mexico, detainees are released if deportation cannot be achieved within 60 days. In Australia, persons who cannot leave the country for reasons beyond their control, for example, their embassy cannot issue a travel document, cannot or will not issue a travel document, are released. So these are some of the best practices that we've looked at and which might be applicable to our situation.
Thank you. I would just like to give a little summary of some of the things we would have discussed and some of our findings and recommendations. More persons enter Trinidad and Tobago illegally than are detected by the systems in place. Many persons enter illegally without documentation, and in this regard, a number of these have been growing from Venezuela. If an illegal immigrant has avenues of support and can post a security bond and persons to support them, they can be released on an order of supervision. They must also have identification documents there. Whereas there are approximately 1,700 persons out on orders of supervision, there are approximately 120 in detention at this time. Security bonds vary by country of origin in the amount with respect to the country of origin of the immigrant. Some illegal immigrants refuse to cooperate with officials and they do not sign visa documents, etc., and this can retard the repatriation process. The Immigration Department has 19 special inquiry officers, and the stenographer pool is limited, which from time to time may present blockages to the repatriation process and the inquiry process. Where there are detainees with families and proof of familial ties, all efforts are made to provide orders of supervision to such detainees. Orders of supervision are intended to be short-term, but may last upwards of 2 years or more, depending on the circumstance of the detainee. The current Immigration Act does not recognize asylum seekers. Therefore, refugee seekers are more often than not placed on orders of supervision, and they may be released on orders of supervision, but the circumstances would dictate whether or not that happens. It is not an automatic release. It depends on the circumstance. Immigration officers are rostered to interact with detainees to provide information on their immigration status. They interact with enforcement officers to provide information to detainees. It must be noted, however, that some detainees express the desire for provision of more regular information updates on their individual cases. Asylum seekers at the IDC may be unregistered and may have difficulty meeting with Living Waters community to become registered. Living Waters community and the IDC have agreed on standard operating procedures to facilitate this process, which is triggered by a statement of request by the detainee. Living Water community has indicated their desire to have freer access to the IDC to interact with persons who, through third parties, have indicated their intention of applying for asylum status. This bears for the discussion between the Ministry of National Security, the IDC, Living Waters, and the UNHCR. A deportation order may be served to a detainee, but this triggers the process of repatriation, which involves the provision of travel documents, a ticket, and a flight to their country of origin and the cooperation of the detainee. So this may make the repatriation process of varying length. With regard to policies, the costs of detention should be factored into the time frame determined for completion of the different stages of the repatriation and detention process. Alternatives to detention have been explored in Trinidad and Tobago. However, there are other avenues which may be explored and applicable to us, which should be figured into any policy decisions on repatriation. So these are just some of the things we would have discussed, and I want to again thank the officials from the Ministry of National Security, from the Immigration Detention Center, from the Immigration Department. I want to thank the officials from Living Waters who have been here with us, and the members of the committee who made themselves available for us to pursue this most important inquiry and public hearing. At this point, I would like to thank the listening and viewing audience and declare this meeting now adjourned.